matter of the Commissioner of His Majesty's Resident and Husband, NGV Financial.
Yes, Mr. Good morning, Your Lordship, Lordships. Just to give you some idea of timing, I'm hoping to finish issue 1 by 11:45, possibly 12, to give friend Mr. Stockham time to deal with issue 2. At the close, well, I think probably almost an extra time yesterday, I showed you references to paragraph 8 of the commentary, and I want to say a little bit about Fowler here. HMRC skeleton made a somewhat oblique reference to Fowler. It said that section 269B operates in a deemed world purely for tax purposes, i.e. treatment of a stapled entity as a domestic corporation for US federal income tax. But 269B is a case where a stapled entity is deemed under the law of the US to be effectively a resident of that state, and on that account fully liable to tax. That is exactly within the wording of paragraph 8 that I showed you yesterday. Ms. McCarthy developed her arguments orally yesterday.
Would you mind if we just had paragraph 8 in front of us?
Certainly. It's in Authorities 1, and it's at divider 6, page 101.
Thank you. Are you referring to the reference to deeming there?
Yes.
That you took us to yesterday?
Where a person is deemed according to taxation will say to be a resident.
Okay, but then it gives the particular example of diplomats.
That's an example, yes. A diplomat from the sending state,
indeed,
deemed to be still resident there. But you've seen other examples of deeming. I might not just pick up this point now. The examples of deemed corporate residents that were referred to yesterday, the Upper Tribunal derived them from my skeleton in the Upper Tribunal, and the skeleton contains footnotes to the sources, which were Widrig, and also another academic source in the same book as Widrig by De Breur, which is at Authorities 51. I don't need to take you to that, but if you wanted to know...
Sorry, they both refer to other deeming...
Other deeming provisions, corporate deeming provisions.
And,
yes.
Sorry, were you referring there to your skeleton below?
Yes.
Okay, are there details?
Yes, yes.
Yeah. Okay.
I don't have the note here of... I can give you the note of the paragraph, but you'll see that it's there's an indented 3 examples there in the footnote. I think it's footnote 92. If you look at the text there,
well remember
the paragraph.
It's footnote 92 in the Upper Tribunal skeleton.
That's right.
Thank you.
Or around that area. Yes. So Ms. McCarthy developed her arguments orally by seeking to identify 2 types of deeming, and by referring to section 269B as a black and white type of deeming. Firstly, there is no basis for that distinction between 2 types of deeming in Fowler. Paragraph 27 of Fowler, which I don't think you were taken to, but I'm not actually going to take you to, but you might want to note, paragraph 27 summarizes the case law on the varying impact of different deeming provisions. It doesn't make a distinction between 2 types of deeming.
No, but the point that was being made, as I understood it, was that you have to, if you take the HMRC thesis, that the connection has to have some locality, has to have some sort of, I can't remember quite the phrase that Ms. McCarthy used, but anyway, has to be a local connection.
Yeah, a relevant local connection.
You can have a deeming provision that incorporates some form of local connection, but says, we're not going to look any further, that's good enough, and we're going to deem you as a matter of domestic law to be resident here, for example. Or you can have a deeming provision that says, regardless of the fact that you have no local connection, we're still going to deem you here, that you're resident here. And that you do, when you look, it's paragraph 30 of Fowler, I think, that says to you, what you have to the question you have to ask yourself is whether it was envisaged by those who entered into the treaty that the latter part of, the latter type of deeming provision would be read into the treaty provisions, effectively.
Yes, but paragraph 30 of Fowler is concerned with the treaty is applying in the real world. I think that's
Yeah.
what the Supreme Court says
You
there.
ask yourself whether there's
And-
anything in the treaty that requires the articles of the treaty to be applied to the fictional deemed world, which may be created as a matter of domestic law, or whether they're to be applied to the real world. And Article 3.2.
Two points there. In Fowler, the diver was an employed diver, and the attempt using Article 3.2 was to treat him as a self-employed person, therefore changing the factual matrix in order to bring him within a different article of the treaty.
Yeah.
This is not the type of deeming
No, this
that
is a different sort of
269B is applying to. And so when we're talking about the real world...
Sorry, can I just pause there?
Sorry.
Is it that type of deeming? It is, I mean, it doesn't quite say this in section 269B, but it is effectively treating a foreign corporation as a domestic corporation.
Because the
that's what
US
Arnold's point.
taxes domestic corporations, it's effectively a shorthand for taxing them on a worldwide basis. It's not changing the facts. It's not saying that GEFI is now to be treated as US incorporated. It's effectively, rather like the UK provision in 1988, saying it will be treated as resident for tax purposes. That the US equivalent is a domestic corporation. And so 269B is not seeking to alter the factual matrix. It's seeking instead to apply, in effect, the definition. It's effectively extending the definition of a US domestic corporation to cover a stapled entity. And as a consequence, that entity becomes liable to tax. It's another way of defining who are resident and therefore who are liable to tax on a worldwide basis. That's very different from what Section 30 is applying. You have
Paragraph
to start
30.
paragraph 30.
Yeah.
You have to effectively start with who is resident in a contracting state by asking who is liable on a worldwide basis. Now, we say that if you're liable on a worldwide basis, that is on the basis of a criterion of a similar nature, that is it. Melania Friend says, no, you've got to go further and ask about what is the basis for that criterion if it's not one of the enumerated ones.
Just for completeness, my lady's referred to paragraph 30 of Fowler. We were also taken to paragraph 25,
Yes.
which is the one where a distinction is drawn between a deeming provision resolving some legal or factual uncertainty and a provision which, on its terms, says only apply to employed divers. Now,
Yes.
Ms McCarthy made the point that if you look at 269B, it applies to foreign corporations
Yes.
and it treats them as domestic corporations. So I'm not quite sure I've yet grasped the distinction you're drawing.
The distinction, in a sense, is between seeking to change the factual matrix by regarding an entity as somehow factually different and seeking simply to change the legal results of those facts by effectively extending the definition of a domestic corporation. Domestic corporation equals resident of the US for tax purposes, and so this is an effective way of extending that definition. It doesn't alter anything about where GEFI is incorporated, doesn't change the stapling, but it has the legal consequence.
But
Well,
this is just
and would you
software.
accept that you just said it doesn't alter everything about where GEFI is incorporated, and likewise it doesn't deem GEFI to be resident in the USA either, does it?
I'm not certain I agree with that, actually, because the US doesn't use the term resident. The point I've been making.
Well, exactly. But that's the point, isn't it?
No. The US uses the term domestic corporation as a way of imposing worldwide taxation, and that is what we would regard as that a resident company in the UK is similarly taxable on its worldwide basis. So it's the definition. It's how the US gets into residence.
So it follows necessarily that the blue logo example would also fall within your definition, because if the US amends section 269B to say any company with a blue logo is a domestic corporation, then it's called.
There are a number of answers to the blue logo. We said it's a silly example. Countries do not, in their tax systems, take a step like that.
Let's take a different. Let's take a different, maybe less example, which you can't levy that particular accusation at. Let's say the US decides to treat all foreign subsidiaries, maybe in countries with a tax rate lower than X percent, as US, in the same way as 269B. So it's not a logo. It's all foreign subsidiaries meeting certain criteria are now to be treated as.
We make a number of points on that. I mean, first of all, what you're effectively describing is actually controlled foreign corporation
legislation. No, I'm saying I'm not. Let's get away from the CFC rules as such. That's a whole other debate. Yeah. Just imagine the words of 269B applied to foreign subsidiaries.
Yeah, it would be another way, effectively, of dealing with foreign subsidiaries. There's 2 points there. Firstly, if that was the US rule at the time a treaty was negotiated, effectively the UK would be taking that. Alter makes the point, which I'll show you, that countries are deemed to know each other's laws when they enter into a treaty. So if the UK entered into a treaty with a country that had that rule, then it cannot be said to be bad faith to have that rule. If they subsequently change the law, then that's when Pacta sunt servanda, Article 26, the question of good faith comes in, because that was not what was foreseen at the time of the treaty, that the country would extend in that way. Okay. It could then potentially lead to a reaction of terminating the treaty if it substantially changed the bargain between the countries. I mean, so I don't think it's not an issue that can be resolved simply by saying, well, would that come within the terms of Article 4.1?
But I can see, I mean, it may well depend on the scope of the good faith obligation, but the US may decide, as it clearly did decide in the case of Section 269B, that there were good US domestic policy reasons to enter into such a rule and maybe provide exactly as 269B actually does, that it applies notwithstanding any treaty. And there might be good policy reasons for that go way beyond the particular provisions of the US-UK double tax treaty. So resorting to good faith, the good faith argument isn't necessarily an obvious answer to this either, is it?
If it alters the balance between the countries, treaties are negotiated on the assumption that there are mutual benefits, there's an element of reciprocity between them. And so if it alters the balance, then I would say that it does affect the good faith. Certainly countries don't have to justify their termination of a treaty in an action like that. But I emphasise 269B was in force 17 years before this treaty was concluded. The Memorandum of Understanding with the Dutch treaty makes it clear that the US, there was a public document that indicated that the US understood 269B to give effect to a resident person for treaty purposes, and the UK understood that. And then the UK entered into a tiebreaker clause, which was a unilateral tiebreaker clause that meant that if there was no agreement on the residence of a dual resident entity, the UK would give credit. The US did not give a reciprocal obligation.
Okay. So explain to us how the UK-Dutch Memorandum of Understanding is admissible as an aid to construing the UK-US treaty.
It's not an aid to construing it, it's a factual element in exactly the same way as the expert for HMRC drew that to the attention in his report, and he took it from that.
I'm sorry to interrupt you, but I just don't understand that answer, and I'm sure it's my fault. So you accept it's not admissible as an aid to construction?
I'm not seeking to rely upon it as an aid to construction. I don't think it
Well,
is admissible in those circumstances.
If it's not
But
admissible as an aid to construction, how can you rely upon that? That's what I'm struggling to
I'm
understand.
only pointing to it for exactly the same reason that the expert on US law from HMRC gave, and that is it was evidence that at the time that the UK treaty was concluded, there was a published position of the US. I am saying exactly what the HMRC's evidence, the HMRC's expert is that.
So, I'm sorry, Mr. Baker, I may be missing something here, but how is something that is inadmissible rendered admissible because the other side's expert refers to it?
I think exactly for that reason, the evidence of the expert.
Sorry, how can expert evidence render that which is inadmissible admissible?
I'm not saying that it's rendering it admissible. I accept that it is not admissible as an aid to interpretation. It is simply a factual matter, and it was that there was a public document at the time of the treaty that indicated the position of the US government. And countries are regarded as knowing each other's tax laws at the time they conclude a treaty.
They're regarded as knowing each other's tax laws, but we do have to be careful here. If we say it's not admissible and it is established that opinions of tax authorities, practices of tax authorities are not relevant in deciding what this treaty means. I mean, it might be said against you that the fact that HMRC's experts saw fit to mention it is neither here nor there. He may have just felt that that was his professional duty and he's not familiar with the rules of English procedure.
I emphasise, I'm not seeking to rely upon it as an aid to interpretation. It's clearly not binding. I'm relying upon it simply for what it factually states, or what the expert on it factually states. I wanted to go back to what I'm saying about the commentary. The FTT on the commentary quoted paragraphs, but then did not discuss the commentary in its discussion and conclusion section, which is somewhat astonishing, bearing in mind that there's a Supreme Court authority that the commentary is a permissible aid to interpretation. The Upper Tribunal, and this is paragraphs 90 to 113, electronic 142 to 146, discussed the commentary at some length and took 5 points from the commentary. We respectfully agree with all those 5 points, and they're referred to in those paragraphs. So far as HMRC's skeleton on the commentary is concerned, we responded to that at paragraph 66 to 77 of our skeleton, and I only want to make a number of points in response partly to what my learned friend said yesterday. The skeleton says that the previous version of the model was not relevant, the 1963, but that version did not contain the second sentence. The first sentence alone of Article 4.1 is sufficient to ensure that only persons subject to full or worldwide taxation are residents of a contracting state. Thus the phrase "by reason of" and the various criteria are essential to restrict liability to tax on a worldwide full or residence basis. HMRC, notably in their skeleton, did not note the last 2 sentences of paragraph 4, which I took you to yesterday.
Paragraph 4
of the commentary to Article 4. HMRC's central contention has been that the domestic definitions of residence should broadly correspond to international norms. But nowhere does the commentary say that. Rather, the paragraph 4 of the commentary says exactly the opposite. No standards are laid down for domestic law. My learned friend referred to the change in UK law under which companies incorporated in the UK are treated as resident, and it notes the domicile of corporations is based on the place of incorporation. But that gives rise to a question, not answered, I think, by HMRC, by my learned friend, why companies incorporated in the UK were not treated as treaty resident before 1988. They were domiciled in the UK. If they were incorporated, they would have been domiciled, and domicile is referred to in the treaties. The answer is because liable to tax by reason of domicile has to mean liable to tax on a worldwide basis by reason of domicile. And before 1988, companies were not liable to tax by reason of their incorporation or domicile. On deemed residents, and perhaps this comes back to Lady Justice Whittle's point, paragraph 43 asserts that the commentary supports the position and that residence depends upon the underlying reasons for the deeming. And that cites Wildrig and Vogel in support. That is not what the commentary says. The commentary that I showed you earlier at the end of paragraph 8, the commentary says the definition of a resident also covers cases where a person is deemed to be a resident. Also covers must mean that the definition also applies to deemed residents.
Sorry,
Where are you?
It's difficult to follow this. I'm afraid.
I'm sorry, I'm trying to...
I realise that, but it's important.
It's at the end of
follow.
paragraph 8. It's the provision I quoted to you at the end. And it refers to also covers. The end of paragraph.
I can't find that.
Also covers cases where a person is deemed. Page 101, paragraph 8, provision.
8.1?
No, 8.
8 itself.
101. It also covers cases where a person is deemed according to the taxation law of a state. You see
Sorry,
that?
I'm
about,
really
It's not at the
following
end
that.
of paragraph.
I can't
It's about the fourth sentence.
7 lines down.
Yeah.
It's the end of the part that I was quoting yesterday. I'm sorry. It's,
In the minutes, that's right at the beginning.
Yes.
Of the
yeah.
So, and what's your point about also?
That does not support Melania Friend's submission that the residence depends upon the underlying reason for the deeming. There's nothing there about explaining the underlying reason for the deeming. I think the simple fact is that HMRC has no answer to paragraph 4 or the parts of paragraph 8 of the commentary, which provide strong support for GEFI's case. Nor does HMRC have an answer to the fact that nowhere in the commentary does it state that a criterion for imposing residence-based taxation has to be based on a territorial or legal or direct link to a state. That's the relevant local connection. That's not stated anywhere in the commentary. Quite the contrary, paragraph 4 states that conventions do not lay down standards. So with that, I have completed my comment on the commentary. If I may, I will make some submissions with regard to the second sentence of Article 4.1. This goes particularly to the FTT decision, where the FTT was in error when it said at paragraph 61, just for note, that's Core Bundle 12, page 214, that it was clear from the second sentence of Article 4.1 that it would not include any person liable to tax only in respect of sources. The argument seems to be that the FTT accepted that the second sentence excludes everyone liable to tax on a source-only basis. Therefore, by virtue of that second sentence, the first sentence, when it says liable to tax, is automatically referring only to tax on a worldwide basis. And so the words by reason of the enumerated criteria add nothing. They add nothing to the limitation to worldwide taxation. If they're given a meaning, it must be to impose some additional qualification, which is my learned friend's relevant local connection. That seems to be the argument that the FTT accepted. On this point, my learned friend's submissions have, with respect, remained somewhat unclear. Yesterday, at least 4 points, she referred to the second sentence not being limited to diplomats. For example, in the transcript of page 54, lines 13 to 15, she said, only those liable to taxation at source would be excluded from treaty residence by virtue of the second sentence. And it seems my learned friend is still seeking, as she did in her skeleton, to support the decision of the FTT on this point. The question of the second sentence is explained at paragraph 8.1 of the commentary, and you've already seen that, so I don't need to take you to it, that it was added for those who are considered to be resident according to domestic law, but are subject only to taxation limited to income from sources. It gives the example of a foreign diplomat. That explains that the second sentence is not there to exclude from liable to tax all situations of source-only taxation.
Can I just, you may be coming back to this, apologies if you are. It was also pointed out to us that the way the second sentence appears in the convention that we're concerned with is clearly not related only to diplomats and the like, because of the reference to
permanent
establishment. Are you coming back to that?
I wasn't going to, but...
Right, maybe you could address that, because it puts a rather... We've got to interpret... I appreciate the importance of the model, but we've got to interpret this convention.
This was included following the US model. I won't take you to it, but if you look at the US model, which is in the authorities, you will see that the US model also includes permanent establishment. Taxation of a permanent establishment is a form of source taxation.
I apologise for my ignorance, but what is the US model?
Pardon?
What do you mean by that? I'm sorry, I'm ignorant about this. I'm aware that we have an OECD model. What do you mean by US model?
The United States also has a model tax treaty that it uses for negotiating conventions.
I'm not quite sure I understand the concept of a model in that context. I mean, it may have its preferred text as its starting point for negotiations, and that I can understand. That's inevitable. But in what sense is it a model?
Well, first of all, may I just give you the reference? It's Authorities 4. It is the US preferred text, and it's a published model. Those who are seeking to negotiate with the US would expect that this is the US's negotiating position. And that wording that Lady Justice Falk has referred to is in the US model there. Permanent establishment is a form of source taxation. It's where a non-resident company has a branch or agency in a country. If it's a form of source taxation, why is it necessary to include it there? I think that the reason is because permanent establishments are not separately resident of the state, but they may be taxed on their income that is outside of the country in which they are located. If you imagine a branch that is operating in the US, but selling also into Mexico. And so it's a form of source taxation, but not limited only to US source. And that seems to be the reason there. What we say about its inclusion is that it doesn't assist a learned friend at all. It doesn't in any way take away from the historical points based upon the OECD model and the explanation that was added after 1977 to exclude those who are taxable only on local source or, like permanent establishments, not a resident but may be taxed on local source and possibly some other income outside the country. I hope that answers your question. And also, have I explained the US model, Lord Justice Arnold? Yeah.
Thank you.
Yeah. Summarising then, the second sentence of Article 4 does not, as the commentary to the OECD model of paragraph 8.1 explains, exclude all cases of source-based taxation. It only excludes cases of persons who would otherwise satisfy the domestic law test of residence, but enjoy a special exemption or some other treatment.
So you're referring to the, I apologise, you're referring to the second sentence in the model.
That's right, yes.
So the example of someone who otherwise would be resident,
Yes.
but whose taxation treatment is limited to sources. When I look at the convention we've got to interpret, it's not being used in that way. That's the reason I asked the question
Yes.
about permanent establishment.
Well,
it's being used in quite a different way.
It's being used in a way to exclude those taxable only on source, but also to make it clear that a permanent establishment, even if it might be taxed not simply on, say, US source income, is also excluded.
That's not what it, with respect, I don't think that's what it says. Look, I'm looking at page 116, top of page 116. Term doesn't include any person who is liable to tax in that state in respect of income from sources in that state, only of income. That's, I understand that, and your point on it, or of profits attributable to a permanent establishment in that state.
Yes, it's the permanent establishment that is situated, so it doesn't
In
include...
let's say in the United States,
yes.
for the sake of argument.
Yes, yes. A permanent establishment, say a UK company that, let's take it for 30-something. Let's suppose there's a French company that has a permanent establishment in the US. It's liable to tax in the US. It may be liable to tax, it'll be liable to tax on income derived from the US. It may be liable to tax on some income that comes from other states like Mexico. And this makes it clear, I believe, that such permanent establishments are also excluded. You're quite right, it is a slightly different reason from the first point. Yes.
Hence my question
Yes,
to you.
yes, it is a slightly different reason.
I think it is very different to
Yes.
diplomats in, say,
Yes.
the United States.
But the first part of it is clearly covering the diplomats. That's the wording from the OECD. If I may then, I leave the second sentence, I hope my submissions on that, and turn to the international case law. The Upper Tribunal examined, in particular, the Crown Forest and the Alta cases some length at paragraphs 124 to 137. Its summary on Crown Forest is at page 130 and on Alta at page 137. If I may, I'd like to take you to Crown Forest, which is in Authorities 1, Divider 23. And if I may, I'm going to identify some paragraphs I'd like to ask you to read separately, and then I want to read just two paragraphs myself. May I ask you separately to read page 473, paragraph 45, 478, 56 to 58, 480, 59 to 61. But I would, if I may, like to take you to page 471. And paragraphs 40 to 41, I don't think you've been shown. This is page 471, divider 23. I want to begin with the first part, at the beginning of paragraph 40. I agree with the appellant that the most similar element among the enumerated criteria is that, standing alone, they would each constitute a basis on which states generally impose full tax liability to worldwide income. It's quoting an earlier version of Vogel and an American work, Joseph Eisenberg. In this respect, the criteria for determining residence in Article 4, Paragraph 1 involve more than simply being liable to taxation on some portion of income, source liability. They entail being subjected to as comprehensive a tax liability as imposed by a state. In the US and Canada, such comprehensive taxation is taxation on worldwide income. And I'll leave you to read the rest of 40 and 41. Now, our submissions on Crown Forest are as follows. Firstly, central to the Supreme Court of Canada's decision was that any criterion of a similar nature meant a criterion establishing worldwide taxation under the domestic law of one of the contracting states. That is part of the ratio of the judgment, and I ask you when you read the paragraphs to bear that in mind that that is our submission. The learned friend says it's only obiter. There is nothing in the judgment that in any way indicates that the criteria to be regarded as resident for treaty purposes required anything additional to worldwide taxation. The case we say is authority that worldwide taxation under domestic law will suffice to satisfy the definition in Article 4.1. In that case, the company Norsk had a territorial connection only with the US and was taxable only on US source income and didn't satisfy this requirement. Secondly, the judgment does not provide any support for HMRC's position that worldwide liability is necessary but not sufficient. Nowhere does the judgment consider any point that anything other than liability to worldwide taxation is required. And thirdly, in the paragraphs that I've referred you to, the absence of the second sentence is discussed, and the Supreme Court correctly explains the function of the second sentence and that it does not change its view on the meaning of the first sentence. HMRC's skeleton on Crown Forest, there are 2 points I'd like to just emphasize there. We deal with this in our skeleton, but just 2 points. Firstly, HMRC maintains that the FTT was correct in its understanding of Crown Forest, and it appears that HMRC in its discussion of Crown Forest is taking exactly the point on the second sentence that I dealt with before, that it's a distinguishing feature of the case. But the Supreme Court Canada, as you will see when you read the paragraphs I've referred you to, state that the absence of the second sentence does not have an impact on the decision. And my second point, that HMRC's primary point in regard to Crown Forest, and that's in their skeleton at paragraph 57A, is that the case establishes that worldwide taxation is a necessary but not sufficient feature to satisfy Article 4, the first sentence of Article 4.1, or Article 4.1. But the ratio is that worldwide taxation is a necessary feature. It says nothing at all of it being sufficient. There is no suggestion that any other criterion of a similar nature requires any element other than liability to worldwide taxation under domestic law. So it does not support.
So can I just make sure I understand what you say the ratio is? The ratio is that worldwide taxation is necessary.
Yes.
Full stop.
Yes.
Okay.
That's right.
That, would you then accept that that means the question of sufficiency is left open because it was not necessary for the decision.
The element of sufficiency is left open from that case, and the FTT got it wrong when it understood, when it said that Crown Forest was authority for sufficiency, and that's paragraph 62, thank you, of the FTT's judgment.
Okay, I mean, in reality, what is going to matter in this court is our reading of Crown Forest rather than the FTT.
Yes.
So it may be better to focus on Crown Forest rather than what the FTT said about
But
it.
if you accept, as you just have, that the question of sufficiency was left open because it wasn't necessary to the decision, how can you say that it's ratio?
It's sufficient. No, I'm not saying that sufficiency was part of the ratio. I'm saying that the worldwide taxation, the requirement of worldwide
Sorry,
taxation.
I apologise if my question was unclear. You have accepted that the Supreme Court left open the question of whether worldwide tax was sufficient. And you've accepted that because you've accepted it wasn't necessary to their decision. On those premises, could you explain to us how it is that you submit that it is part of the ratio of the decision that worldwide taxation is enough?
Worldwide taxation is necessary, but I'm not certain if I put it perhaps clearly enough in my acceptance. The Supreme Court did not have to answer the question of whether it was sufficient or insufficient, and so that was not an issue that was before the court. But what the court said was that worldwide taxation is the common feature of all of the enumerated criteria. It is also the common feature of other criteria of a similar nature, and that is not obiter, that is part of the ratio of the judgment. And it's relevant because Norsk argued that by virtue of the fact that they had taxation in the US on business income arising there, they came within the scope of other criteria of a similar nature. And the Supreme Court said no, because all the criteria require worldwide taxation. And that's, we say, is the ratio of the case.
And
If I might turn to Alta, and again, I'm going to ask you to read to yourselves separately paragraphs 52 to 62, but I am going to take you to a few paragraphs that you've not seen. It's at Authorities Volume 2, Divider 44. And I'd just like to take you to paragraphs 34, which is at page 973 in the electronic bundle. And it's the statement at the second part of paragraph 34. Mr. Justice Hogan observed that parties to a tax treaty are presumed to know the other country's tax system when they negotiate a tax treaty. They're presumed to know the tax consequences of a tax treaty when they negotiate amendments to the treaty. That only makes sense. That's just making good the points that I've referred to Alta on that several times. If you would like to read for yourselves paragraph 35, I don't think I need to read that out. I'd just like to read that. And then if I might ask you to go to paragraph 55, and this is on page 984. And this is in the context of discussing the object and purpose of Article 4.1 of the Convention in that case, you'll recall that it was accepted that a Luxembourg incorporated company was resident, but the Canadian authorities sought to deny the benefit of the treaty under the Canadian General Anti-Avoidance Rule. And that required an analysis of the object and purpose of Article 4.1. And it's that discussion of the object and purpose that is in the paragraphs from 52 onwards that I've asked you to look at. But I want particularly to focus on paragraph 55. 55 says, aside from the liable to tax requirement, the purpose of Article 4.1 is not to establish specific standards for defining residence. This provision expressly states that residence is to be defined by the laws of the contracting state of which the person claims to be a resident. The provision of the treaty is modelled almost word for word on Article 4.1 of the 1998 OECD Model Treaty, whose commentary also makes it clear that the intention was to leave the core definition of residence to domestic law, not to bilateral tax treaties. And you'll see there a quotation from paragraph 4 of the commentary. You've seen that in the 2000 version. So that's confirmation from the Supreme Court that it is accepting the commentary at paragraph 4 that the intention to leave the core definition of residence to domestic law. And then paragraph 59 on page 986. And this is concerned with the issue that Lord Justice Falk has asked about the subsequent changes to tax law. Nonetheless, I acknowledge that treaty partners do not have the unfettered liberty to alter or redefine residence as they wish for the purposes of a tax treaty. The broader context of international tax law and the law of treaties helps to understand what was within the contemplation of Canada and Luxembourg when they drafted Articles 1 and 4.1 of the treaty. Pursuant to the principle of pacta sunt servanda, parties to a treaty must keep their sides of the bargain and perform their obligations in good faith. It's Article 26 of the Vienna Convention. Domestic law definitions of residence should therefore broadly correspond to international norms and not have the effect of redefining residence in a way that takes the words unmistakably past their accepted usage, including the definitions of residence that were in effect in the two states at the time the treaty was drafted.
Okay, just can I clarify? I assume the reference to cousin there is to the text we were taken to yesterday, not a different text.
No, it's the same text.
Thank you.
Yes, yes. But that paragraph is clearly considering the issue that we were discussing earlier of a subsequent change after a treaty has been negotiated, because it refers to the definitions of residence that were in effect in the two states at the time the treaty was drafted. And that's the issue of good faith and pacta sunt servanda. I have, I think, 4 submissions on ALTA. First, ALTA provides further support for the decision in Crown Forest, but it goes beyond Crown Forest in rejecting an argument that sought to impose an additional requirement for residence on top of worldwide liability under domestic law. That was the minister's argument of sufficient substantive economic connection. Second, as you've just seen, the judgment emphasizes that liability to tax means full liability under domestic law. A double taxation convention does not establish standards for defining residence in domestic law. It leaves this entirely to the domestic law. Thirdly, the Minister of Finance argued that satisfying domestic law was not sufficient. The majority in the Supreme Court rejected that argument. They considered that domestic law of liability to tax on a worldwide basis is sufficient. so here we say that it is part of the ratio of this case, that sufficiency is an element of the decision on the rationale, the object and purpose of Article 4. And fifth,
Sorry, which paragraph do you say establishes bindingly that
it's the discussion
that domestic liability tax on a worldwide basis is sufficient? Which paragraph?
if you read through, it's paragraph 57, it's paragraph 57, where they discuss is not sufficient, definition of resident is not sufficient to qualify as a resident, and that's the argument that is rejected.
This is, though, against the context of it being common ground by the time it got to the court that Alta was in fact a resident of Luxembourg for treaty purposes.
Precisely the point I explained earlier. That was common ground, but nevertheless the Canadian revenue sought to apply the GAR, and in order to do so they had to explain what was the object and purpose of Article 4.1, and it's the discussion of object and purpose, because that leads us into what is the object and purpose of the other criteria of a similar nature. It's irrelevant in a sense to the discussion of object and purpose that they had already agreed that the formal requirement of incorporation in Luxembourg, that was the background.
Okay, but forgive me, isn't the issue here whether, quotes, residents, using the generic term, here via place of incorporation or deemed incorporation, if you like, under 269B, that is the very issue in dispute. The very issue in dispute here was common ground in
Yes,
wasn't
but
it?
the issue in dispute here is what is the meaning of other criteria of a similar nature. And in order to understand, to answer that question, it's necessary to consider the object and purpose of Article 4.1, because that is an explanation of what are the reasons for the enumerated criteria.
Right,
And
so just remind me, Alta, I know Crown Forest does discuss similar nature. It's not directly in point in Alta.
It's not
is it?
directly in point, but the discussion of object and purpose is in point to understand what is the common theme that runs through the enumerated criteria. And so that's why, even though it was an agreed point about Luxembourg incorporation, nevertheless, the discussion that I referred to at 52 to 62 is an explanation of object and purpose which we say should guide you. The case is not binding upon you, it's a Canadian court, but it's a superior court case, and it's discussing exactly the issue which your lordships should be, your ladyships are considering when you're considering what is the meaning, what is the object and purpose, and therefore what is the meaning to be given to other criteria of a similar nature.
But that's why I'm baffled, because as you've just said, rightly, the issue before us is what is the meaning of the words other criterion of a similar nature?
Yes.
And as I think you've just accepted, that question was not before the Canadian Supreme Court in this case.
No, because that's absolutely right.
So
But
how does it help on those two concessions?
because when you're coming to consider the meaning of other criteria of a similar nature, you need to consider the object and purpose, and particularly the rationale behind the enumerated criteria. And to that extent, the views of the Supreme Court of Canada, not persuasive, but not binding, but we say significantly persuasive, because they are looking in effect at the same issue that is underlying your decision here. I can't put it higher than that. That it's not binding. It's not binding.
Forgive me if I can ask one last question. I mean, what you've just said is very realistic, and I understand that. But I'm still puzzled because if I've understood correctly, and I may have got completely the wrong end of the stick, the issue that the Supreme Court was confronted with in that case was: it was common ground that on a straightforward reading of domestic law, the company in question was resident in the state in question. And the question was, well, could the minister get out from under that point by saying, well, no, you've got to read resident in a different way?
No, that's not the way it is. The minister is accepting that on the face of the treaty, the Luxembourg company, Alta, was a resident of Luxembourg, but the minister was seeking to apply an overriding provision of Canadian law, the general anti-avoidance rule.
Indeed.
For the purpose of applying that, the minister had to show that there was an abuse of the object and purpose of Article 4.1. And that's why the Supreme Court comes to discuss in those paragraphs the object and purpose. And that discussion, we say, is not binding upon you, but we say it's very persuasive when you come to look at, albeit a different question.
So it's all about the object and purpose. Yeah.
Exactly.
Okay, thank you.
If I may, my learned friend cited two other cases. I think that's all I wanted to say about Alta. I have time to say. Is first of all the Indian General Electric case. That's authorities 27, and you've seen the paragraphs from it. It's a decision of a first-level tax tribunal. There are, in fact, I think 2 levels of appeal above it. I have endeavoured to find out whether the case has been referred to by a higher court in India, and research indicates that it hasn't. So it remains as a first instance decision. You'll recall that in that case, the GE company, different company, sought to rely upon the Netherlands-India Treaty on the basis that it had dividends from a source in the Netherlands. And so in a sense, it's very similar to Crown Forest in that they were seeking access to a treaty on the basis of merely a local source of income. It's correct that the Income Tax Appellate Tribunal quotes from Vogel. My learned friend took you to the quote from Vogel. But the tribunal does so without any explanation of the relevance of what Vogel says. And in fact, that quotation is completely unnecessary for its decision. The company concerned merely had income from a source in the Netherlands, and the Income Tax Tribunal need only have said it is not a resident of the Netherlands because it is not liable to tax on its worldwide income. The quotation from Vogel, which goes broader than that, is not necessary for the tax tribunal's decision. So we say that it's a court of first instance, or even a court, it's a tribunal of first instance, and the quotation from Vogel is not part of the reasoning of the court. It's not necessary for its reasoning. So far as the Portuguese Supreme Court is concerned, that's at authorities 31, and I will ask you, if I may, to...
There's no title in the text of this case.
The Portuguese case?
Yes, it's in the sort of index, but not on the...
Yes, I think Portuguese cases are referred to simply by their number.
I see.
There. So this is case 0882/10.
Thank you.
We say it's very difficult to derive anything very much from the case, partly because it's hard to see what is the judgment and what is simply a quotation from what appears to be a summary of previous case law. But one aspect of the case that is notable, and this you can see at page 591, about halfway down the page, paragraph 3. And this is part of the submissions on behalf of the revenue there, but I think it's stating Portuguese law. The income received in Germany was voluntarily declared in the first family tax return, in which the taxpayers expressly acknowledged that they were resident and had their tax domicile in Portugal, as this was the centre of vital interests. And just on the opposite side of the page, number 11, the link with Portuguese law, by virtue of the fact that the respondent is a member of a household resident in Portugal, is perfectly legitimate and understandable, since according to the, I think that's the Portuguese income tax law, the true taxpayer is the household. It would seem from what is said there that the taxpayer in Portugal was not the individual, the husband, but was the household. And the household was regarded as resident in Portugal under domestic law. In the discussion that you were asked to look at pages 595 to 597, the summary that's quoted there notes that a tax treaty has to be applied person by person. And so taxation of a household would not answer the question of whether a person was resident or not. That seems to be when the Supreme Administrative Court was looking to determine on a person-by-person basis why it had to look for links with one of the two countries. And it noted that the husband was resident under German law and spent most of the year in Germany. So it appears to be a somewhat unusual situation where the taxpayer is not the individual but the family. But whether I've understood that correctly of Portuguese law, it appears that that is the case, and certainly the reference to person by person suggests that there is a different approach that has to be adopted from domestic law. I have 3 points to make, though, on the case, all of which indicate that it's unreliable. Firstly, could I ask you please to turn to Authority 60, Divider 60, at page 1425. This is a summary of the case, and you'll see the title of the case there is given as 0882/10, so that does appear to be the title of the case, Justice Falk. This is a summary from the tax treaty database of the International Bureau for Fiscal Documentation. The IBFD maintains an electronic database of tax treaty cases. And this is the summary of this case. Could I ask you please to have a look at the editor's note in the middle of page 1425 and perhaps read to yourselves what the editor says. You'll see the editor considers the decisions are highly dubious. My second comment in the case is it's not clear what is the decision of the court and what is a quotation from a summary of previous cases. And finally, it's notable from the judgment that there is a dissenting judgment. It's a 2-to-1 decision. At the end of the report, the translation at divider 31, you'll see at the bottom of it there is a dissent. This is page 599. Lisbon, 12th of January 2011. 3 judges, Valente Torau, Isabel Marques de Silva, Brandao de Pina, who gives a actually it's a concurring decision, but on different grounds. So it appears that not all the judges of the Supreme Court agree with the line of cases. We say that neither case provides authority for the proposition that a criterion of a similar nature needs to be one which involves a territorial or other similar link to a taxing state. If I may turn to academic writings, properly understood, we say that academic writings support our arguments. Specifically, Vogel and Widrig follows Vogel. Your Lordship and your Ladyship should have received a version of the latest edition of Vogel.
Has anyone checked whether there are any material differences?
So you haven't? There are no material differences.
Thank you.
I didn't, yes. And if I may, I'm going to take 2 paragraphs from this. What's now paragraph 61 on the second text of the page of text. There are 2 possibilities for interpreting the term of a similar nature. Under a broader function interpretation, any domestic feature triggering unlimited tax liability is sufficient. And that is effectively our position in this case, GEFI's position. In contrast, a narrower territorial understanding requires both unlimited liability to tax and a territorial connection between the taxpayer and the state concerned. In our view, the territorial interpretation is preferable, and Vogel then gives 3 reasons for that, and you'll recall that the Upper Tribunal considered those and considered that each of those reasons was invalid for that conclusion. But that's what Vogel says about the treaty based upon the OECD model. When Vogel comes at the next page, paragraph 65, to discuss nationality or citizenship or listing in an official register, at paragraph 65, he concludes that citizenship and incorporation are not territorial links. So if a treaty includes territorial incorporation and citizenship, then a territorial interpretation is not appropriate because there are terms used that do not have a territorial link, specifically citizenship. You may be a citizen of a country without being...
Does he say that anything to the effect that that means that the view in those treaties, even a modified version of what he says in 61 is not the right approach?
No, he doesn't say that, but I think he's driven to that. It must be driven to...
He simply says, does he not simply say that nationality, for example, unless stated otherwise, is insufficient for establishing residence?
What he's saying actually is that it's not a territorial link. It is a long-standing link, however, it does not create a territorial link. A national state may never have set foot on the state's territory. So in 61, he gives 2 alternatives. Yes. One is functional, our position, the other one is territorial.
Okay. I mean,
now he
clearly,
said,
yeah, I just wanted to make the point that I have to say I find the notion of incorporation in a territory in the context of a company as opposed to individuals with nationality quite difficult not to describe as a territorial link for myself, because I just wondered if you could comment on this. A company is a legal construct. It doesn't exist as a tangible real world item, and its incorporation in a particular territory is an obvious legal link to that territory in the context of something that doesn't exist apart from that country's legal system.
may I sidestep that by saying citizenship? You may have citizenship of the country clearly without any territorial link. This includes both incorporation and
Again, it
citizenship.
depends what you mean by a territorial link, isn't it? Because, as the editors of Vogel rightly say, nationality constitutes a strong connection between a country and an individual.
But he never-
So, in that sense, it is a territorial link.
But he goes on to say that in his terms, it's not a territorial link. That's what he actually says there.
It depends what you mean by territorial
But
link, doesn't
we're
it?
trying to understand what Vogel would say about this treaty, and I quite accept that he doesn't say, therefore, a functional approach. But I think he's driven to that by his offering of two alternatives in paragraph 61, of which he says that citizenship, not territorial, and therefore we say the only approach is the functional approach. I think I'll leave that there if I may. On Robert Kuzar, can I just ask you to note, this is of authorities divider 49. Could I ask you to perhaps consider parts 3.1.3.5, this is just for reading, 3.1.4.1 and 3.1.4.2. That's electronic pages 1227 to 1232. And in particular, the conclusion at the bottom of page 1228, where he says the enumerated criteria should have something to do with taxation on the residence principle in the particular state.
I'm sorry, I can't find that on that page. Where is that?
Bottom of page 1228.
That's what I'm looking at, yes.
Final
Oh, I
paragraph.
see.
Final
Right,
paragraph.
you picked it up in the middle of the sentence.
Yes.
All right.
The essence of Cousin's thesis is at 3.1.4.1, which I've asked you to read, and that is that 4.1 is based on the distinction between residence and source taxation. Article 4.1 contemplates residence taxation, and the residual criteria must be ones used by states to impose residence taxation.
So, can I be clear? Do you say he's right or he's wrong?
We say that he supports us, because if you read through all of it, he would, we say, endorse our view that section 269B imposes what he terms residence taxation.
Well, indeed. Can we look at 1231, which is the passage we were looking at yesterday,
Yes.
where he concludes by saying imprecision is replaced by misdirection, where residence taxation is replaced by expressions such as full tax liability or comprehensive taxation. So my understanding is that Cousins is saying that full tax liability is not the correct criterion. The correct criterion is what he calls residence taxation.
Yes, he's objecting to the use of the words worldwide or full and prefers the use of the words residence. His concern is that if you talk about worldwide taxation, that's too narrow, because it would include, it could be argued that it requires taxation on all worldwide income and similarly full taxation. It's his, right the way through 3142, his criticism is of the use of the terminology, but he then comes instead to the use of different terminology, which is residence basis taxation. It's a terminological point, not an argument against the concept of residence taxation. Those are my last comments on the academic points, and those are our submissions on our primary argument. If I might turn to our secondary argument, which is if we're wrong on the interpretation of Article 4.1, we nevertheless satisfy the requirements of Article 4.1 because we do have connections with the US. That is, we have a sufficient connection with the US. We are stapled to a US corporation, and we are indirectly owned by a US corporation, and that is sufficient connection to the US. The Upper Tribunal did not need to consider this point because they considered that we were correct on the interpretation point. If I may, our arguments before the Upper Tribunal were set out in our skeleton for the Upper Tribunal at paragraphs 95 to 96. And that's the supplementary bundle, divider 10, pages 269 to 273. And I adopt our submissions there.
Okay, you don't. Did you cover this in your respondent's notice?
We
I don't think you
not,
did.
I don't think we need to because it's another argument it's the argument that we've put before the FTT. It wasn't necessary for the Upper Tribunal to deal with it. We had won on the first issue.
But that shows you that you do need a respondent's notice, doesn't it? Because the argument before that you successfully advanced before the Upper Tribunal was that the FTT had erred in law,
Yes.
and they agreed with you so far as interpretation was concerned. But if they were wrong about that, as you've just pointed out, there was no alternative basis for the Upper Tribunal's decision. And therefore, if they were wrong on interpretation, that means the FTT's decision stands because they were wrong to find that error of law in the FTT. And that's why you need a respondent's notice.
The argument was raised on alternative grounds on issue 1 before the first tier tribunal. It seems unusual to consider that we need a respondent's notice when on issue 1 we are the successful party and that we are simply seeking to raise an argument on the same issue that we put before the court below. If we put two arguments before the first tier tribunal and we're successful on one, do we need a respondent's notice to maintain that second argument on the same issue before before yourselves?
Well, I don't think that's the correct analysis, but I don't think it matters either because HMRC haven't taken the procedural
Yes.
objection.
Milena Friend, I think, said that, mentioned that, yeah. Yes. The Upper Tribunal did not deal with this point, but I should note at paragraph 148 of their judgment, they did note that GEFI had substantive economic ties to the US. On the second, this alternative issue, a tribunal having decided that we were unsuccessful on the interpretation and that there was an additional condition to be satisfied, a tribunal would have had to regard the enumerated criteria and then explain what that additional condition is in order for it to come to a conclusion on whether we satisfied that or not. one of the errors of the FTT was that it simply said there was an insufficient connection with the US without identifying what connection was needed. The FTT's decision on this point is at paragraphs 63 to 66. And the nub of the decision, much of it is recording submissions by myself and Ms. McCarthy, but at the end of paragraph 65 they say, I agree that given the differences that do exist for tax purposes, see paragraph 29 above, the connection or attachment is between the stapled entities rather than to the countries concerned. That's paragraph 65 of the FTT decision. With respect, we say that that is a pure non sequitur. The differences that are referred to are three differences in the tax treatment relating to the branch profits tax, the inability to join in a consolidated return, and the inability to claim exemption under a tax treaty. Those are the differences referred to in paragraph 29, but there's no explanation as to why the differences in tax treaty should be determinative of the issue of a connection with the US sufficient to satisfy the interpretation which the FTT is putting on Article 4.1. Paragraph 65, the FTT accepted HMRC's argument that the connections between the stapled entities, GEFI and GEFI Inc., rather than between GEFI and the US. But the FTT did not specify what connection or attachment to the US would have been necessary, nor does it explain why a connection to GEFI Inc. is not also a connection to the US. It's not clear why the connection with another entity is not sufficient, particularly if it has a consequence of liability to worldwide tax. Put another way, why can the US not provide in its law that a connection with a US person of a particular nature is sufficient to give rise to worldwide taxation? In effect, the position of, the FTT in effect made an error of law in failing to identify its interpretation of Article 4.1 and setting out a legal test based upon that interpretation, which reflected the common features of the enumerated criteria and applying that test to GEFI. That, we say, is an error of law and not an error in the evaluation of the facts. The evaluation of the facts would have come at a later stage. The first duty on the FTT was to interpret Article 4.1, to explain what connection was required. It did not do that, but instead it's part of its judgment here relies entirely on a non sequitur. In effect, this leaves a purely arbitrary position. Before determining whether an entity satisfies a requirement of the connection, the tribunal should logically have set out the legal test of what connection was necessary. That was not the approach taken by the FTT here, and we say that that is itself an error of law, not an error with regard to the evaluation of the facts. If you forgive me one moment. Unless I can help you further, I will now yield to Mr.
Thank you very much.
Thank you.
May it please the court, as my learned leader indicated, I'm addressing issue 2A on behalf of the respondent. I'll refer to the respondent as either GEFI or GEFI Limited, and I'll probably flip between GEFI and GEFI, and I apologise in advance for that. I'll contrast that with the general partner in the limited partnership, which I'll refer to as GEFI Inc., and I'll refer to HMRC or the revenue interchangeably. HMRC have confirmed they're not pursuing issue 2B, and that's in paragraph 3 of their first issue skeleton argument. So issue 2A is all that's left of issue 2. And GEFI's written submissions on that are set out in tab 5 of the court bundle in our respondent's notice skeleton argument. That skeleton argument was the first skeleton argument GEFI produced, so it contains a substantial amount of introductory material, summary of GEFI's case, a summary of the facts, and an overview of the issues. I don't propose to address the court on any of those matters unless there's anything in the facts I can assist with. The only point I would note is that GEFI's appeal in respect of issue 2A does not seek to challenge any of the primary findings of fact by the First Tribunal. In terms of the outline of my submissions, I propose to follow the structure of the skeleton argument and to take it in 5 stages. First, to frame the issue, which I can hopefully do briefly. That will involve taking the court to the relevant articles in the treaty and also addressing my Lady Justice Falk's point yesterday about Article 3.2 and what role that plays. Second, I'll come on to GEFI's positive case, which is to identify the correct legal principles going to the UK tax law meaning of business, why on the primary facts found by the FTT, GEFI was carrying on a business in the relevant period, recognising, of course, that that does not take GEFI anywhere on issue 2A unless the First Tribunal made an error of law, and hence the next stage in the analysis, which is stage 3, identifying the errors of law in the FTT decision. That will involve identifying and examining the substance of the tribunal decision on issue 2A and identifying the errors of law that the FTT made. I'll submit that each error that the First Tribunal made is sufficient without more for this court to set aside the First Tribunal decision, but cumulatively they are more than sufficient. And at that stage it's open to this court to adopt GEFI's positive case on the facts as the correct analysis. And I'd make clear at the outset that that's what I would urge this court to do. GEFI does not ask this court to remit this matter to the First Tribunal. In the context of identifying the FTT's errors of law, I'll also consider the attempts to bolster the FTT decision on issue 2A in both the Upper Tribunal decision and HMRC's skeleton argument. And I will demonstrate that the First Tribunal decision on issue 2A cannot be salvaged. It is wrong in law and it should be set aside. Stage 4 is to look at the errors of law in the Upper Tribunal decision. Now, it's absolutely right that I propose to focus on the First Tribunal decision because it's necessary to show that the first tier made an error of law. However, contrary to what is suggested in my learned friend's skeleton argument, it is also necessary to look at least at one part of the Upper Tribunal decision, because HMRC do positively rely on one aspect of the Upper Tribunal's reasoning that in my submission is simply not found in the First Tribunal decision. So given that, HMRC cannot be right to maintain that the analysis in the Upper Tribunal decision is legally irrelevant, as they do at paragraph 51 of their skeleton. So I do need to address that point. Subject to questions of timing, there are a few other areas in the Upper Tribunal decision that I would like to come to that are relevant, but I'll have to judge whether I have time to get through those. I do have quite an amount of material to get through, so I'll be taking it at a bit of a lick. If I am going too fast, please do stop me. I'm sure the court will. Nonetheless, the focus of the submissions, as I've outlined, will be on the First Tribunal decision. I will spend significantly less time on the Upper Tribunal decision, and that'll be more of a coda to the main submissions. Stage 5 will just be a conclusion outlining how the court should dispose of this issue. So turning then to stage 1, framing this debate, that's paragraphs 42 to 49 of GEFI's skeleton argument on issue 2. First point, issue 2A only arises if HMRC succeed in their appeal on issue 1. So on GEFI's view of the world, my submissions before you are effectively a moot point. Nonetheless, I would still ask the court to decide issue 2 in any event. It is an important point with potentially wider implications, and the incorrect decision of the First Tribunal endorsed by the Upper Tribunal should not be permitted to stand. Turning then to the relevant provisions, it is all now common ground as to how the relevant provisions of the treaty operate. I wanted just to quickly turn them up and to show them to you. The first point to note is that it's common ground that the limited partnership is transparent for tax purposes in both the US and the UK. So GEFI Limited and GEFI Inc. are treated for both UK and US tax purposes as receiving interest on loans. So that's why the first article we have to look at is the interest article, which is Article 11. That's in tab 7 of the authorities, page 124 to 125. I'm going to ask you to quickly turn that up. We see in Article 11.1 the general rule that interest is taxable in the contracting state where the beneficial owner of the interest is resident. Then lower down the page at Article 11.3, that general rule does not apply if the beneficial owner of the interest resident in one contracting state carries on business in the other contracting state in which the interest arises through a permanent establishment or PE situated in that other contracting state, and the interest is attributable to that PE. And in that case, which is this case, Article 7, the business profits article applies. The business profits article starts at page 119 of the same tab.
Can I just ask a quick basic question? The decisions below and the arguments in the skeleton seem to proceed on the basis that the question before the court is the meaning of the single word business.
Yes, my lord.
I would question that. Is it not properly the meaning of the composite phrase carries on business?
My lord, that was a point that was raised at stages in the correspondence between the parties and briefly before the first tribunal. It was not a point that was pursued, it was by HMRC it was pursued in the correspondence. It was not pursued before the FTT or the Upper Tribunal. There is a reason for that, which I'll come on to. There's an Australian case called Teal, which addresses the point and says that, if, in effect, carrying on is just a connected verb that doesn't add anything to the test. So the approach, my lord is absolutely right, below has been that the test and the question we are concerned with is the meaning simply of business.
What if Teal is wrong?
Well, if Teal is wrong, then it would follow, and this is a point I'm actually going to have to come on to address my Lady Justice Falk's point as well. If Teal is wrong and in some way it's said that carrying on business has a different meaning, well, 2 points. First of all, I don't think as a matter of UK law, which is the test that the lower tribunals applied, that it would alter the meaning of business in any event. But secondly, if it was said, and this is somewhat preempting the point that my lady made, that it has some international meaning that has not been addressed or canvassed by any of the lower tribunals, then it would follow that both of those tribunals' decisions are wrong, because they would have applied the wrong test.
In fact, an alternative view is that it's not even limited to carries on business. It's carries on business in which the interest arises.
Well, my lord, my submission is that the test we are concerned with is the meaning of the word business. That's been common ground throughout. It's the position that was applied below. As I say, we may be in a position where if the court takes a view that that is not the correct test, then we simply don't have a decision on it.
The correct question. I just don't understand how you can purport to interpret the word business in a vacuum. It's meaningless. You've got to see, at the very least, the context in which you're asking the meaning of the word. And at minimum, you're asking yourself, is whether the beneficial owner of the interest carries on business in the other contracting state in which the interest arises.
Well, there's no question that the beneficial owner of the interest is, both GEFI Limited and GEFI Inc. So there's never been any debate about that point. In which the interest arises, again, is a factual question about the contracting state. Again, there's been no debate that here the interest is US source. Permanent establishment is a concept that is defined in the treaty, and again, I'm going to come on to this, but it is common ground that if there is a business carried on here, then there is a PE, a fixed place of business permanent establishment. And that we fully accept as a treaty concept, but it's been, again, common ground throughout that there is a PE.
All right. Well, anyway, the short answer is you're telling me this is all common ground. And the
Well, to
should
some extent, I would
interfere.
say it has always been common ground that the question is business, and in a sense, that is GEFI's position. I can't really add to that.
Yeah.
Um, So coming on then to the Article 7 business profits test. Article 7.1, page 119, we see there the business profits of an enterprise an enterprise of a contracting state should be taxable only in that state. So default rule, the state in which the entity is resident, unless the enterprise carries on business in the other contracting state through a permanent establishment situated therein. If the enterprise carries on business as aforesaid, the business profits of the enterprise may be taxed in the other state, but only so much of them as are attributable to that permanent establishment. So, my lord, as I've already hinted, it is common ground that as a result of those provisions, if GEFI was carrying on business in the US through a PE, then the US has the primary right to tax the profits of GEFI attributable to the PE. And then the UK is required under Article 24.4a to give double tax relief by way of credit for US tax on the profits. And that's essentially because here the interest would be US source income. That's why the US has the primary taxing right. For your note, Article 24.4a is at tab 7, page 141, but I don't propose to go to it because there's no debate about it. So as a result of that common ground, the court will have seen that the terms of issue 2a are agreed, and that agreement is recorded in paragraph 3, subparagraph 9 of the First Tribunal, which simply records the statement of agreed facts and issues. So issue 2a, properly stated, is during the relevant period, so that's the calendar years 2003 to 2008, did GEFI Limited carry on business in the US through a permanent establishment situated therein?
Well, quite.
Indeed. There's more common ground than that. I mean, the joy of this
that
case...
seems to me to be an accurate statement of the issue.
But the joy of the case is that so much more of it is common ground, my lord. So, as I've set out in paragraph 47, there are 4 other matters of common ground which refine the issue in dispute even further. First, it is common ground that the interest on the loans is US source income. Again, that is principally because both Gelco and GECC, the debtors under the loans, were US resident companies. Second point, issue 2a concerns whether GEFI Limited was carrying on business by virtue of its membership of the LP. And it is common ground for these purposes that the activities of the LP are attributed to GEFI Limited and GEFI Inc. And that can be seen both in paragraph 70 to 71 of the First Tier Tribunal and also in paragraph 31 of HMRC's skeleton argument for this court. Just to read the relevant sentence, for your note, it's page 93 of the core bundle. Rather, the only relevant activities were those of the limited partnership, which were in turn to be attributed to GEFI as limited partner. So we have the activities carried on by the LP being attributed to both the general and the limited partner. Now we've seen, and you see in the expert evidence as to Delaware law, that a Delaware LP is a separate legal person, but it is transparent, as I've already outlined, for tax purposes in the UK and the US. And so the activities of the LP are regarded for tax purposes as activities of GEFI Limited and GEFI Inc., just as the income of the LP is regarded as income of GEFI Inc. and GEFI Limited. Third point, it is also common ground that if GEFI Limited was carrying on business, then there is no separate debate about whether that business was carried on through a permanent establishment in the US. That is in paragraph 70 of the First Tribunal. And the reason for that is made clear in paragraph 14 of HMRC's skeleton argument here. It's common ground that if business was carried on, then it was carried on through a fixed place of business in the US, more specifically the offices of the general partner in Stamford, Connecticut. Fourth point of common ground is the point I've already addressed with my lord, that the reference to carrying on business, or the reference to the words carrying on in both 11.3 and Article 7 does not add anything further to the debate. HMRC have not suggested before any of the tribunals that it does, and they don't in this court. And GEFI do not seek to place any weight on those words either. So as a result of all that common ground, issue 2 reduces down to, did GEFI carry on business, and the word business is the key word, in the relevant period? That debate turns on the meaning and application of the word business. That then brings in the final piece of the framing of the debate, and that is the fact that it's also common ground that business takes the meaning that it has for UK tax law purposes, and that's the point that my lady raised yesterday. Specifically, it's the meaning that it has for income tax, corporation tax, and capital gains tax. Now, in response to my lady's question, my learned friend indicated that it was up to GEFI to indicate if it adopted some form of international fiscal meaning of business. My answer to that is short, no, it does not. GEFI's position throughout this litigation at all times has been that business takes its UK tax law meaning. Now, in my submission, the Upper Tribunal analysis on this point, which is at paragraphs 157 to 162 of the Upper Tribunal decision, is entirely correct for the reasons it gives. If I could just ask the Tribunal, because my lady raised the point, just to go back to that. It's at tab 9 of the core bundle, page 155 to 156. And if I could just ask the Tribunal to read through paragraphs 157 to 162 over the page. Now, that analysis is not disputed by either side. It is clearly based on Article 3.2, which you can see that the Tribunal had in mind. If we look back at Article 3.2, because we looked at it yesterday, it's at page 115 in tab 7 of the authorities bundle, so back a few pages from where we were. So broadly, any term not defined will take the, if I can paraphrase, the tax law meaning in the state that's applying the legislation, unless the context otherwise requires. Well, as the Upper Tribunal noted, neither the party has suggested that the context does otherwise require, or unless the competent authorities agree on a common meaning pursuant to the provisions of Article 26 of this convention. And again, neither of the contracting states has done that. Just to show you, in their natural environment, as it were, the other provisions that the Upper Tribunal referred to, Article 3.1d is at page 113. I should say, because we're going to come on to it in a second, this is the equivalent of the provision of Article 3.1h in the model. You can see there the term business includes the performance of professional services and of other activities of an independent character. That reference is explained if you go to the commentary, which is at tab 6, page 98. And if I could just ask the court to read paragraph 10.2 of the commentary. It refers to subparagraph H, that is the point, that it's the same provision, the numbering is, or the lettering is different in the model. Now that paragraph in my submission both explains the reference to business includes professional services. I would just note in that context, when you look back at the page, we're not on that page now, but you'll see some of the other provisions in Article 3 say X means something. In the context of business, it simply says business includes professional services. and services of an independent character. This paragraph of the commentary explains why that is. In effect, the professional services article was removed from the model in 2000, and there was the aim was to unify the treatment of both businesses and independent services or professional services.
I understand all that. It still doesn't quite capture the question I was asking yesterday, which is that Article 3.2 really proceeds on the assumption that there is a relevant meaning.
So there are two questions, my lady, in my submission. One is, does it take its UK tax law meaning? And that's the point I'm addressing now.
Yeah.
I obviously have to come on and show you that in my submission, yes, business does have a meaning in UK tax law, and there are legal principles underpinning that.
I understand that. My question was relevant, whether there's any point about whether it needs a relevant meaning. I appreciate this is common ground, so we shouldn't spend long on it, but...
Well, my lady, I think my submissions are simply, the commentary says it has to take its domestic law meaning and the tax law meaning in preference to any other domestic law meaning.
So you have to see if you can find a tax law relevant, one of the relevant taxes, meaning of the word, and if you can, even if it's in a different context, you apply it. Is that your position?
Well, it depends what one means in a different context. If the word business has a meaning for tax law purposes, which in my submission it does, in the relevant taxes, then that is the meaning that one does. And just to frame that question, I'm not going to come on to make this point, but the way of thinking about that question in my submission is, if in next year's Finance Act, which I'm sure we'll have, if not before, there was a statutory provision simply referring to consequence X will apply if company Y is engaged in a business or carries on a business. Would that concept in that statute have a meaning for UK tax law purposes? And in my submission, plainly it would. There are more than enough cases, there are not lots of cases, there are more than enough cases to demonstrate that that concept has legal principles underpinning it. It is not subject to a uniform, exhaustive statutory definition. Of course I accept that. But my submission is there are clear principles underpinning what that concept means for a UK tax lawyer, and it's that meaning that we have to apply when we're applying these provisions. My lady, just to finish that point off.
Can I follow that up?
Of course, my lord.
Because is it your submission, well, you may tell me again that this is common ground, but is it your submission that the word business, or even the composite phrase carrying on business, has a uniform meaning throughout all UK tax law?
I would say that in respect of the taxes we are concerned with, yes, it would. Because if you were looking at income tax, corporation tax, or capital gains tax, if a court was tasked with determining, a UK court was determined in a UK tax appeal with determining the meaning of that concept, in my submission, that court would go to the cases I am going to go to, would draw the principles I am going to draw, and that would be the correct meaning of that concept. So yes, it's a uniform meaning, but certainly not a statutory definition. It's not a uniform statutory definition. That's a point I'm going to just address briefly on the Upper Tribunal. But just to make a little bit more of the Article 3.2 point, I fully accept that Article 3.2 is slightly unusual in that respect, in that it does incorporate a number of domestic law concepts into the treaty. But in my submission, that is the effect of Article 3.2. And in my submission, that's not an unwelcome result, because it's very difficult to see how one state would be able to derive some sort of international fiscal meaning of business. We'll see in my submission that the US and the UK take very different views as to what business means. And so, in a sense, it's entirely sensible for the treaty to have regard in that context to the domestic law meaning. And it rather emphasises the point made by my learned leader that in lots of instances, double tax treaties do not dictate matters to contracting states, they leave questions to their domestic law. One final point, my lady, just if I can take the point to its logical end conclusion, if the parties are wrong and that business does not take its UK tax law meaning, then it would follow in my submission that the decisions of both the FTT and the Upper Tribunal would be wrong in law, because certainly the FTT would have applied the wrong test, and the Upper Tribunal would have then endorsed that decision. It would be based on the wrong legal test from business, and on that view, GEFI's appeal would have to be allowed on issue 2A in any event. If that were the case, I would submit this court actually would have no option. Okay, fine.
Let's not go further, because
my lady, I'm happy to leave
made
it
it
there.
clear that it's common ground. We've
Yes.
not heard otherwise. So.
I'm grateful, my lady. That's helpful. The one final point I would note, though, is it is now common ground, but it is not at all clear what HMRC's position was before the FTT. And I'll need to return to that point when we look at my submission that the FTT either applied or was at least influenced by the US law test for business. And it's relevant in that context that HMRC's position was anything but clear before the First Tribunal. Turning then to stage 2, which, as I've outlined, is GEFI's positive case on the point. So I'm first going to look to set out the correct legal principles to determine whether GEFI Limited or indeed any other company is carrying on business as a matter of UK tax law. And then how, if those principles are applied correctly to the primary facts found by the FTT, it leads to, in my submission, the inevitable conclusion that GEFI Limited was carrying on business throughout the relevant period. So first, the meaning of business in UK tax law. That's at paragraphs 50 to 53 of GEFI's skeleton. First, as I've already intimated, fully accept that business does not have a general or uniform statutory definition in UK tax law. Now, just note the Upper Tribunal sought to draw a contrast between business and trade in that context, and it said that trade has a, quote, uniform meaning. Well, in my submission, even trade doesn't really have an exhaustive statutory definition for UK tax purposes. I mean, to take one example that the Upper Tribunal referred to, which is section 989 of the 2007 Income Tax Act, the court, I'm sure, will be more than familiar with the fact that trade is defined to include any venture in the nature of a trade. Well, that is certainly not an exhaustive or even really a very informative definition. In my submission, instead, both the meaning of trade and business for UK tax purposes are informed by legal principles that are set out in the case law. And those legal principles delineate what constitutes either a trade or a business for the purposes of UK tax law.
But can I ask you this basic question?
Yes, my lord.
Given that you accept there is no definition, it would seem to follow that the exercise is one of evaluation by the tribunal.
I don't accept that, my lord. In my submission, there are legal principles that clearly underpin the meaning. So I accept there is no, I can't point to a statute that says for UK tax law purposes.
You can't point to a case that gives a definition either.
I can, my lord, yes, I'm about to. I can certainly point to cases that identify legal principles that underpin the meaning of business. And in my submission, any subsequent tribunal would be under an obligation to have regard to those principles and to apply them. In my submission, the First Tribunal in this case did not apply those legal principles.
I appreciate that you say that there are legal principles, and of course, to some extent, that's not in dispute. But I want to be clear. Are you saying that case law has established a definition of the word business for this purpose?
Well, there's a danger of engaging in a semantic debate as to what a definition is, and I don't really want to engage in that.
Well, because you accept there's no statutory definition.
I do.
But of course, sometimes courts do define terms that are not to be found defined in statutes.
Indeed, but there are ways of defining a concept that do not give an exhaustive definition. So you can have different forms of definition. In my submission, there are clear legal principles that a court needs to apply in determining whether a particular activity is a business. So to that extent, yes, there is that form of definition in case law. I can't, with the possible exception of the American Leaf case, which I'll come on to, I can't say that a court has said, for all purposes and for all times, this is what business means, but I do submit that there are clear legal principles that apply. And I've already sort of framed the debate in that sense, that if we did have a new statute that said, if company X is engaged in business or carry on business or whatever connecting words we want to use, this consequence applies. If that was in the Next Finance Act and a UK tribunal was tasked with construing those words, in my submission, they would be required to have regard to this case law, to derive the correct principles and to apply them. And if they fail to do so, in my submission, that would constitute an error of law of failing to have regard to the relevant legal principles. So in relation to business, and the court will have seen it from the skeleton argument, that in my submission there are 4 decisions of the higher courts, and I use that term because it's not technically the senior courts, but the higher courts of the Court of Appeal, House of Lords and Privy Council, that in my submission are key to informing the meaning of the concept of business for the purposes of UK tax law. I would ask, of course, the court to read all 4 of those cases. I'm sure the court may well already have done so, or may not need to. Just to set them out in chronological order, and to some extent chronology will be important to one point I'm going to make. They're in the bundle in chronological order, helpfully, but they are Korean Syndicate, which is a 1921 decision of the Court of Appeal, Wesley Estates, which is a 1923 decision of the Court of Appeal, the South Bahar Railway Company, which is a House of Lords decision from 1925, and then, bringing matters much more up to date, there's the American Leaf Blending case, which is a Privy Council decision concerning Malaysia, and that's from 1978. Now, GEFI relies on each of those cases to a material extent in support of the relevant legal principles.
I take it you would accept that American leaf blending is not binding on this court.
I accept that it's not binding, my lord, although I will come on to say that there is clear Supreme Court authority, indeed a nine-panel Supreme Court, saying that it is of great weight and persuasive value on courts at every level of this country, but I absolutely accept it is not binding on this court.
Okay.
Nonetheless, in my submission, if this court were not to have regard to it, or if a lower court were not to have regard to it, in my submission, that would constitute an error of law, because it's plainly a relevant decision, if not a binding decision. So in the skeleton argument at paragraphs 50 to 51, I seek to distill 5 legal principles as to the meaning of business. That is predominantly relying on those 4 cases, and that's exactly what GEFI did before both the First Tribunal and the Upper Tribunal. Now, in a slightly unusual course, what I'm proposing to do is just to summarise all 4 of those cases at the outset, to put them in context, give the potted facts and what they were concerned with. That will then allow me to take you to the relevant passages of those cases, unless that exercise wouldn't assist. But I'm conscious that it may assist the court to know what the cases were about. I will try and do it as quickly as possible. The Korean Syndicate case, as I've said, 1921 Court of Appeal, that concerned the concept of trade or business for excess profits duty in the 1915 Finance Act No. 2. The facts were that a limited company had the principal object of the acquisition and working of mining concessions and turning them to account. The key clause of the memorandum is clause 3.1, which you'll notice at page 221 of the authorities bundle. 1905, the company purchased a 50% interest in a gold mining concession in Korea, which was the Su-an mine. And in 1908, 3 years later, it leased that concession to another company in return for a profit share, which was referred to as a royalty. The Court of Appeal didn't like the terms lease or royalty, but that's what they referred to in the agreement. The case concerned the accounting periods of the 31st of March 1916 and 1917, so some 8 and 9 years after that agreement was entered into. And the only income in the relevant period of the company was the royalties derived from that agreement and the interest on bank account deposits. The only activities in the period were the collection and distribution of those funds and paying a premium on a sinking fund policy. The question was it carrying on business, it being accepted that it wasn't carrying on a trade? Decision of the High Court, Mr. Justice Rowlett, held not carrying on business, and it's important to note that it's a decision of Mr. Justice Rowlett because his lordship is going to feature fairly prominently in the cases going forward.
He's got a case wrong, hadn't he?
He may have got more than one case wrong. I think at a going count there was at least 4, but we will come on to...
It's quite rare for that, Judge.
Indeed. And hence the significance of him recognising the error. But in the Court of Appeal, it was unanimously held that the company was carrying on business in the relevant period. That was Lord Sterndale, Master of the Rolls, Lord Justice Atkin and Lord Justice Younger. And if I can very briefly summarise what the court held, it held that the company was following through on its objects, in particular clause 3.1, of turning the concession to account. Those were business objects, and therefore the company was carrying on business. Second report is at tab 12 of the authorities bundle, and that's I'll refer to generally as the Wesley Estates Company case, 1923 Court of Appeal. Different tax, corporation profits tax under the Finance Act 1920, but clearly a forerunner to corporation tax in some sense. That concerned whether a British company was carrying on any trade or business or undertaking of a similar character, including the holding of investments. Now, it actually dealt with 3 cases, all of which were appeals from Mr. Justice Rowlett, and the Court of Appeal reversed Mr. Justice Rowlett in every single case. There, the Court of Appeal was Sir Ernest Pollock, Master of the Rolls, Lord Justice Warrington, Lord Justice Sargent. Summarising the result quickly, Wesley Estates, it was unanimously held that the company was carrying on business. Eccentric Club Limited unanimously held that it was not carrying on a business or undertaking of a similar character. And South Bahar Railway The majority, with Lord Justice Sargent dissenting, held that the entity was carrying on a business. That case went on to the House of Lords, and I'm going to address that separately in respect of the House of Lords decision. So just quickly giving you the facts of the two remaining cases there in the Court of Appeal. The Wesley Estates Company was a company formed to administer an estate that had previously vested in a large number of beneficiaries. That estate was transferred to the company in 1900. The company derived income from leases of lands and coal mines. It only ever sold 2 plots. That's at page 245 of the PDF. And the company never actually worked the mines itself. It was simply receiving income from the leases. And as the leases fell in, the company would renew them. Again, we're here, in this case, was concerned with the accounting period of the 30th of June 1920, so some 20 years after the company had received the estate, and unanimously held, as I've already outlined, that it was carrying on business. That was the final decision in respect of that appeal. We then have the Eccentric Club Limited, which is very much of its time as a factual matter, but it concerned a company limited by guarantee. I would just put a pin in that point. The other cases are all concerning companies limited by shares. This was a company limited by guarantee that was a social members club. There was provision that any profits or surplus on winding up were not distributable to members. Instead, they would be to be applied as the committee might determine. And the members simply paid for any services they used. The club was not run to generate a profit. Unanimously held there, not carrying on a business or undertaking of a similar character, and that was the final decision in respect of that appeal. Only 2 more tabs to go. So the penultimate case is the South Bahar Railway Company. That's the case that went on from the Court of Appeal in Wesley to the House of Lords. So we have the 1925 decision of the House of Lords at tab 14. Similar to all the other cases in Wesley, that was concerning corporation profits tax in section 52 of the 1920 Finance Act. So the same test. And the facts of that case were, in 1895, a railway company entered into a contract with the Secretary of State for India, with the company providing funding and materials for the railway line, Secretary of State providing the land and constructing the railway through its agent. The company received a percentage of gross earnings, and the railway was then managed by the Secretary of State for India. So that was 1895. 1906, there was a deed by which the company divested itself of any interest in the railway in return for a £30,000 annuity that was payable twice yearly. That annuity was commutable at the option of the Secretary of State into a lump sum of £684,000 odd. Again, this was concerning an accounting period 14 years after that 1906 deed, so 31st of December 1920. And the only activities of the company in the relevant period were receiving the annuity payments. That's all it did. Held unanimously that it was carrying on business, and the respondents were not called upon before the House of Lords. Again, to very briefly summarise their Lordship's judgment, the company had undoubtedly been carrying on business originally, and the 1906 deed didn't cause it to stop being in business. And certainly the fact that it was only receiving income in the relevant period and had been for 14 years didn't prevent it from carrying on business. Final authority is the American leaf blending company, SDN BHD versus the Director General of Inland Revenue. That's the 1978 Privy Council case, and this is the case on which I place most reliance and is, in my submission, clearly the most important authority on the meaning of business in UK tax. As I've outlined, that was a case concerning Malaysia, the Income Tax Act of 1967, and specifically Section 43. The relevant test for the Privy Council was whether the income concerned was statutory income for the relevant year from each of the sources consisting of a business. So its sources consisting of a business is the relevant phrase there. Facts of the case concerned a company which is an SDN BHD. At the risk of giving evidence, that is a Sendirian Berhad company, which is a private limited company in Malaysia. That company bought land and erected a building, or buildings, a factory for making cigarettes, and a warehouse for storage. February 1961, it began manufacturing cigarettes, but that activity was so unprofitable they stopped doing it in November of the same year. They then traded tobacco until 1964, and in 1964 abandoned the tobacco business entirely after making losses of almost $400,000 and granted a license to use the warehouse to a third party. In 1967, the remainder of the premises, so the factory, were emptied and also let, And by 1968, there had been a total of 5 successive lettings. Now, the court is, or the Privy Council is clear that when it refers to lettings, it means licenses that were granted. They weren't leases, but that's a small point of detail. You had 3 lettings of the warehouse, 1 of the factory, and 1 of the factory and the warehouse. And the case was concerned with the income tax assessment in respect of rent from lettings for the 1968 and 1970 year. And in particular, the company was seeking to set off its losses against that rental income. And it was only able to do so if the income was from a source consisting of a business. Now, just to give it's important to understand how the case progressed, because the special commissioners held that it was a business. The reason the special commissioners held that was because the letting of property was one of the objects in the company's memorandum. So in effect, the special commissioners held the fact that the company was authorised to let the property necessarily meant that what it was doing was carrying on business as a matter of law. It was entirely dispositive of the point. High Court in Malaysia upheld the special commissioners. Federal Court allowed the revenues appeal. And then it comes to the Privy Council. Lord Diplock, giving the advice of their lordships, held that the entity was carrying on business, but for different reasons to the special commissioners. And I'll come on to show you those reasons in a moment. But I would note there was another argument in the case, which is important to know when you're reading the decision. All courts rejected an argument that because rent was included in the specific charging provision, this income couldn't also be chargeable as business income. It's a little bit like the Fry and Salisbury type debate of are the schedules mutually exclusive. All of the courts, including the Privy Council, held these charging provisions are not mutually exclusive, and so this income can fall within the business income charging provision. But that debate is not directly relevant to what we are looking at, save for one aspect which I'll show you. Now, in my submission, the American leaf blending case is clearly the most important authority on the meaning of business in UK tax law. It is the most recent case at the level of the higher courts. Taking fully on board my Lord's point, the Privy Council is not technically binding on this court, but the Supreme Court decision in Willers and Joyce, which we don't have in the bundle, but we can certainly provide copies if that would assist. It's a very short decision, helpfully, and very clear. A 9-panel court held that decisions of the Privy Council are deserving of, quote, great weight and persuasive value at all levels in English courts. Importantly also, the Privy Council in that case had all 3 of the other cases that I've referred to cited to it, and they specifically refer to Westley, and we'll come on to look at what the court said about Westley in a moment. Importantly also in my submission, that case was considering the meaning of business without any other relevant accompanying wording. So we've seen, when I've set out the tests, some of the other cases, business is referred to in a context of other words, so things like undertaking of a similar character in the Westley case, which could be said to inform the meaning. But the Privy Council, in my submission, was not looking at such a test, it was simply looking at the word business. It also expressly stated that it was considering the ordinary meaning of that concept. Now, that must be taken to be the ordinary meaning from an English lawyer's perspective or from the English legal system's perspective. But if I could ask you just to go to page 399 of the authorities bundle, it's tab 19. So this is in American leaf blending. And if I could ask you just to read the paragraph towards the bottom of that page from just above G to H. Now, it's interesting to note that the Privy Council does identify as one of the instances of a business a bank or money lender, which obviously is of some relevance to our particular factual matrix. But more importantly in that paragraph, the Privy Council is looking at the charging provision, which you can see above between D and E when it refers to section 4. So it says the various paragraphs are given their ordinary meaning. In that context, it refers to the first it must be taken to be referring to the first charging provision, which was of central relevance in the appeal, gains or profits from a business, for whatever period of time carried on. So, in my submission, what the court is doing is it is saying we are going to give the words business, and indeed all the words in Section 4 their ordinary meaning. But in my submission, the Privy Council goes on, as I've already outlined, to give some clear principles that apply in determining that ordinary meaning for the purposes of UK tax law, or for the purposes of, from a UK tax law perspective. So that is the conspectus of the 4 key cases. Hopefully that wasn't too long, too arduous. If I could move on to the 5 legal principles that I draw from them. And to some extent, this is going to be dotting around the cases and showing you the passages I rely on. Clearly, it's important for the court to read all 4 of the cases, but it's also important for me to show you the passages I particularly rely on. So the first principle is that in my submission, business for UK tax law purposes is a very broad concept, and it is a very low threshold to satisfy the test. Now, the first thing to say is that it's absolutely clear that business is a wider concept than trade. And I get that specifically from page 401 of the American Leaf Blending. So if I can just show you that. A couple of pages on.
All your pages are all authority bundle.
Authorities bundle 401, sorry, my lady. It's always the PDF number.
Thank you.
I'm trying to give. But at capital B, you can see, and it helpfully couldn't be said any clearer on this point, business is a wider concept than trade. So we have that in American Leaf Blending, that it is clearly wider than trade. If we go back and see some of the earlier decisions, first of all, the Korean syndicate case in the judgment of Lord Sterndale, Master of the Rolls, with whom Lord Justices Atkin and Younger agreed. If I could ask you just to go to 234, and the Korean syndicate case, as I outlined, is unanimous. Four-fifths of the way down the page, the word business as defined in that section is therefore the governing word here, and it has the widest possible meaning. If we go to the decision of the Master of the Rolls in Westley as well at 258, again, about 4/5 of the way down the page. You see there his lordship saying the words trade or business are very wide words. We know business is the wider concept, so it's the business piece of it that is the very wide piece. Just 2 points to make on the breadth of the concept. The first is that my lady indicated there aren't many cases on the meaning of business. My submission that this is part of the reason for that. Business is such a broad concept in UK tax law that it very rarely is something that features in a debate in litigation.
Well, it's more that it isn't that relevant in
Well,
UK
my lady,
tax
that's
law.
not strictly right. I mean, just to veer slightly out of the world of the specific taxes we're dealing with, in inheritance tax, there's obviously business property relief. The debate in inheritance tax, business property relief, is never about whether there's a business. It is always pretty much about whether or not that business is mainly making or holding investments. Now, I don't seek to rely on that for the purposes of construing the concept here, because it's outside the taxes that we're specifically concerned with. But it's a related point that it is almost always HMRC seeking to assert that the taxpayer was carrying on a business, almost always, certainly in these cases, because either historically or going forward, it is a gateway to tax. And in those cases, and some of the cases we have in the bundle, HMRC seek to maintain that the concept is as wide as possible. And perhaps the most pathological example of HMRC taking that to extraordinary lengths is the decision in tab 24 of the bundle, which is the John M. Harris Design Partnership case. Now, it's a special commission decision. I don't place particular reliance on it, save to note this point. That was a case where a company did nothing other than own a family holiday flat in France. The flat was never rented out. The company never incurred any expenditure in respect of the flat because the individual who owned the company covered all the expenses. Literally, the only thing the company did was to hold the flat. It didn't even permit friends to use the flat. Nonetheless, HMRC sought to argue in that case that the company was carrying on business. This case is extremely unusual in that it's HMRC.
But I see that they failed.
They did fail, indeed, my lord.
So
Yes.
what relevance is that?
Well, my lord, first of all, it is an example. It's one of two examples of the extreme cases or exceptional cases where an entity has not been found to be carrying on a business. My submission is merely that it is not at all clear that success on this issue in this case will ultimately operate to HMRC's benefit in the wider context of the UK tax system, because it is generally not HMRC who are seeking to narrow the concept of business. Now, the second principle that I seek to distill from the case law is in fact two related principles, and they in effect go together. The first is that an important distinction is drawn in the case law between companies and individuals. And the second aspect of it is that there is a strong presumption that a limited company that makes gainful use of its asset is carrying on a business. And I'll refer to that as the strong presumption, occasionally as shorthand. Now, as to the distinction between individuals and companies, we can see that first in the Korean syndicate case. So if I could ask you to go to page 235 of the authorities, tab 11. And if I could ask the court to read from the paragraph that begins near the top of the page, just the whole of that paragraph.
So it's a matter to be considered, is the words.
Indeed, yes, it is a matter to be considered, but it's a clear distinction that's drawn. Worth noting the reference to individuals sometimes coming into existence for no reason is rather charming turn of phrase. But in my submission, clearly drawing the distinction there, that distinction is again pointed to in the Westley case. So if I could ask the court to turn up, it's on a few pages, page 269. And perhaps two-thirds of the way down the page, if I just read this out, it will be easier. But assuming that in the case of an individual, to do such things would not be to carry on a trade or business, it does not at all follow that the conclusion would be the same in the case of a company, the end and object of whose being is to transact the business in question and thereby to make a profit for division amongst its shareholders. See the passage that you have just seen. Now, again, to sort of explain that distinction in sort of slightly more vernacular terms, clearly an individual can exist for lots of other reasons and can do activities for lots of other reasons than a company can. So, to take a slightly homely example, if as a child I had taken the bus to my grandma's house, had done some cleaning and cleaned her car, and she'd given me £10, it could be said that I had utilised or expended my assets on the bus fare to go and generate an income. But no one would sensibly suggest that by doing so I was carrying on a business. It would be done out of familial affection or perhaps obligation or for any number of reasons. That simply doesn't apply to a company. And what the courts are saying is if a company is carrying on transaction that it is created to carry on and generating income, then there is a very different situation to the position of an individual. So that's the distinction being drawn. As to the presumption itself, if I could take you to the eccentric club decision, and it's there, it's Ernest Pollock, Master of the Rolls, page 267, so back 2 pages. Now you'll recall the eccentric club was the company limited by guarantee. His lordship says towards the end of his judgment, the facts of this case are special and peculiar, and while as a general rule, in cases of a company registered with the Appendix Limited, there would be a strong presumption that it was intended to and did carry on a trade or business, yet in my judgment that presumption can be rebutted, and is so where the facts are such as in this case as to negative both the aim and the prospect of gain.
So do you say that's a legal presumption or an evidential presumption?
I say that there is a legal principle that one presumes that a company that is, as we're going to come on to see in American leaf blending, that is utilising its assets to generate income is carrying on a business. And if a court approaches that question without employing that presumption, it has proceeded in an incorrect manner. So I've pointed to the distinction and I've pointed to the presumption. In my submission, importantly, both of those principles are clearly articulated by Lord Diplock in the American leaf blending decision. If I could ask you to turn, it's tab 19, if we could go to page 401. And if I could ask the court to read the second paragraph down, starting in the case of a private individual. So drawing the distinction between a private individual and, quote, a company incorporated for the purposes of making profits for its shareholders. Now that, in my submission, is in contrast to the position we saw in Eccentric Club, where we had a company limited by guarantee that wasn't seeking to make profit. But here, if we've got a company incorporated for the purpose of making profits, then any gainful use of the company assets leads to the, as it says, prima facie presumption. And then it goes on to say that if that activity is letting out for rent, it's not easy to envisage circumstances that are likely to arise in practice where it would not be carrying on business. Now, in my submission, that is making clear that there is the strong presumption that I have sought to identify.
Where does he use the word strong presumption?
Well, he is saying it prima facie amounts to the carrying on of a business, so there is a presumption, and then he goes on to say, in the context of letting out property, it would be hard to envisage any circumstance in which it wasn't carrying on a business. So in my submission, that must entail that it is not an easy presumption to overcome in the case of the limited company. So unlike in the Eccentric Club case, the specific words strong presumption aren't used, although we've seen they were used in the Eccentric Club case, and Eccentric Club was cited to the Privy Council in this case.
You say it was cited, is it approved by Lord Diplock?
It is not specifically referred to by Lord Diplock, no, but it was cited to. Right. So the Wesley case is the one of the four cases that are specifically discussed by Lord Diplock. I'll come on to make that point in the context of a different principle. Just a point on the facts, though. What the court does make clear, or the Privy Council makes clear, is that rental of property, hard to envisage any circumstances where that wouldn't be a business. Now, my submission, if we were looking at an intra-corporate group rental of property at a market rate, no clear reason why this reasoning wouldn't apply to that factual scenario. And in my submission, it's not a very big jump to say, well, intra-group lending at a market rate. Again, why would there be any reason to hold that the presumption was overturned in that instance? Now, on this legal principle, finally, it is important to note that there are further points of common ground. So, first of all, and this perhaps stresses my Lord's point to some extent, it is common ground that there is a strong presumption that a company will be carrying on a business, subject to some caveats which I'll have to address, but it's in paragraph 46 of HMRC's skeleton argument. While it is right that there is a strong presumption that a company will be carrying on a business, now that's subject, as I say, to three caveats which I'll address in the context of addressing HMRC's case. But in my submission, I take it to be common ground that there is that strong presumption. It's also common ground, if I could take it back a few pages to paragraph 35, and this is actually taken from case law, specifically the case of Jowett. HMRC rely on Mr. Justice Park's statement that there can be exceptional cases where a company is not carrying on a business. So again, they're positively relying on that. In my submission, the category of cases where a limited company will not be carrying on a business are exceptional. So that's the second principle, distinction to be drawn and strong presumption. If I go quickly, my lord, I can possibly get through the next principle. So if I might start it, if I have to stop, then I'll stop. But the third principle is that in my submission, it's not necessary for a company to engage in a significant amount of activity in order to be carrying on a business. In other words, there is no requirement in UK tax law for an active carrying on of business. And if I could ask the court, we're on the right page, it's page 401 of American Leaf Blending. If I could ask the court to read in fact, it's easier if I read it. It's just below capital D. The carrying on of business no doubt usually calls for some activity on the part of whoever carries it on, though depending on the nature of the business, the activity may be intermittent with long intervals of quiescence in between. So, first point, the reference there to usually, in my submission, does leave open the possibility that an entity could be carrying on business without carrying on any activity at all.
Well, does he go so far as to say you can be entirely passive?
Well, in my submission, the word usually, and followed by...
Usually calls for some activity,
that must
the activity may be intermittent.
So if it usually calls for some activity, it must follow, my lord, in my submission, that it doesn't always call for some activity. But in my submission, in any event, his lordship is very clear that one can be carrying on business with long periods of, as he says, as his lordship says, intermittent and long intervals of quiescence in between any actions. Now, looking at the earlier cases again, and doing them in a slightly different order because I want to show how this relates to Mr. Justice Rowlatt's earlier decisions. If we look at the South Bahar Railway Company, there's a very pithy statement from Lord Sumner. That's at page 305. Tab 14.
It's about not being busy.
Indeed, business is not confined to being busy. In many businesses, long intervals of inactivity occur. At the bottom of the page, Lord Buckmaster agrees. So that's South Bahar. In Korean Syndicate, we have a more substantive analysis of the point by Lord Justice Atkin. It's page 238.
What case are we in?
Sorry, my lady, Korean Syndicate, so tab 11, page 238. And if I could ask the court just to read the side-ruled passage on that page. First point, over the page you can see Lord Justice Younger agrees with Lord Justice Atkin, but his lordship there is saying it's true that it may be called, if you please, a passive carrying on of a business as opposed to an active carrying on. But he then goes on to disapprove of the analysis of Miss Justice Rowlatt and say an active carrying on is not required. Personally, if any emphasis is attached to the word active, I think it would narrow the meaning of the word business. I'm conscious of the time. If I could show you one last authority, then if I can sort of round off the point. It's Westley, so tab 12 at 269. So, first of all, this is Lord Justice Warrington at the bottom of the page. It seems to me also quite immaterial that the actual operations of the company have been few in number and perhaps of no great importance. If you find a company formed to carry on a business and in fact carrying it on, it cannot matter that its activities have been restricted. And then the Master of the Rolls considers the passage from Lord Atkin, so we should just see that at 261.
Sorry, earlier.
Yeah, going back a few pages, my lady, this is the Master Rolls gives the first judgment of the Court of Appeal. And if I could just ask the court to read from the passage starting a third of the way down the page, you see Lord Justice Atkin in the Korean syndicate case to the bottom of the page. So his lordship refers to Lord Justice Atkin's analysis, says, well, maybe Mr. Justice Rowlett didn't mean it as a definition, but he does say something that I agree with, that whenever at some particular moment a company is doing nothing but receiving an income from its investments, it is not carrying on a business, and he indicates that in certain class of case, although a company is not actively doing anything, the right conclusion would be that the company was nevertheless carrying on a business. Now, importantly, in my submission, Lord Justice Atkin and the Court of Appeal in that case clearly disapprove of Mr. Justice Rowlett's analysis, and clearly Master Rolls here is not approving of that analysis. He's saying, well, maybe he meant something different. I'm going to need to show you what that analysis was, but I can do that after the short adjournment.
But he agreed with what he cites from Rowlett J's judgment at the end.
Indeed, yes, saying, but which is in effect saying you don't need to be carrying on that activity at any given time.
All right, we'll pause there and resume at 2.
Why is it able?